I may, let me say to Gillespie James know, and Mr. Scarry, I've just got a few questions of the Secretary, if I may.
Mr. O'Brien.
Thanks very much. My name's O'Brien, and as you know, I represent BGD. Over lunch, I confirmed with her, and she had some questions she wanted to ask of you. I take it that whilst you've been observing proceedings, you've seen the case notes and the review notes that relate to BGD, prepared by people working within Winlaton and the department.
As they were put up, yes, I recall seeing that.
You heard also in that context my client's evidence to the effect that she felt as though she was to blame for what was happening to her at her dad's, under her dad's hands. Do you understand that?
I heard her say that, yes.
Do you accept that, having seen those documents, there is an element of blame being sheeted home to her from those documents? The wording and language suggests that she's somehow responsible for what was happening to her?
Look, there were partial extracts of documents which give that indication. Whether that was their intent, I couldn't comment on that. But the other thing I think... Well, Council Assisting, sorry to interrupt you, but making the point. Council Assisting was talking about the language used in some of these documents that you've seen. Yes.
And I'm suggesting to you that the language used in some of those documents really was demonstrative of this idea or this concept that she was responsible for what was happening to her. Do you accept that?
As a general point, yes.
She, as you know, commenced civil proceedings against the state, obviously the department, in 2010. You're aware of that?
I am just aware of that, yes.
And did you happen to have a look at those the legal documentation related to that case at all in your preparation for this Royal Commission?
No, I haven't. No, I have not.
You understand that she, her claim against the state was that there had been a breach of the duty of care owed to her by the state. You accept that?
I understand that is her
claim,
yes.
And you, of course, have read her statement as to what she says about those proceedings.
Yes, I have.
And you accept what she says, I imagine, that, given the tenor of your evidence earlier, that she found it a very difficult process.
Yes.
A process at the end of which she threw her hands up and settled.
Yes, I recall her saying, I think, she'd given up.
And there was some settlement negotiations which took place. You understand that?
Yes.
And during those settlement negotiations, there was a denial of responsibility, a denial of full responsibilities to what took place. Do you understand that?
I'm not aware of that.
Well, that's what you've read a statement, haven't you?
Yeah, I can't recall that bit, but yes.
She says at paragraph 137, I was extremely angry that the department said during settlement negotiations that they only knew about the abuse whilst I was at Winlaton, even though the documents in my ward files show that the social or youth workers such as Fitzgerald and Pearl were involved with the family before I was placed at Winlaton.
I recall that bit, yes.
So it's clear that the department wasn't, even in those settlement negotiations, taking full responsibility for what they knew to have happened to her, isn't it?
Look, from the basis of that evidence, that would appear to be the case. Yeah. And as a result, I did make reference earlier in questioning from Council Assisting about in the period since we've moved to a very different model where practices such as that are not the norm.
What happened to her won't happen to others.
I would hope not.
Yes. The other thing that was of concern to her, no doubt, was the absence of these very important documents which are set out in paragraph 134 of her statement. Some of those documents that one of those documents being referred to by Councillor Sissing, that letter to the father.
Yes.
An extremely important document, wouldn't you think, in terms of understanding the culpability of the state and the responsibility that they had and played in your life and in those formative years. You'd accept that?
It's a very important document. Yes, I'll accept it.
And there you have the other documents there. A 1976 document, an April the 6th, 1979 document, documents which were classification action sheets. You see that, and the personal report sheets that are there.
Yes.
They were all important documents which demonstrated conclusively the knowledge of the department about the sexual abuse at a father's hands, weren't they?
They're all important documents, as I think are all documents related to wards of the state from that time. These are the only documents about their life at the time, and they're all important. These documents, yes, they are important for her.
And these documents have been failed to, well, the department had, through omission or by any other means, had failed to disclose these documents to her.
Your Honour, can I object to that question?
Yes. I withdraw it. Sorry.
Thank you.
I withdraw the question. These documents are obviously important documents for her to formulate her own history. Is that right?
Correct.
And they're also important documents for her to formulate in the context of a civil set of proceedings the liability of the state. You'd accept that?
I accept they are important documents as part of those proceedings. They would be, yes.
And of course, she was involved in civil proceedings and settlements without these documents at hand.
Your Honour, I object to that as well. What's been said about these documents, not just now but previous occasions, is quite confusing and confused. There are two issues about the documents, and Dr Hodgkinson gave evidence about the FOI aspects of them. And it's one thing to get documents pursuant to an FOI request, which, as Dr Hodgkinson explained, has to be complied with according to law. And it's quite another thing to get documents in the discovery process in civil litigation. There's been no evidence that there was any defection or any, in fact, discovery in BGD's civil claim against the state. And there should not be any suggestion that the state failed to discover documents. The documents are here now because the state produced them to the Royal Commission. And Mr O'Brien, in particular, fudges it and seems to imply that the state did something wrong, and that's exemplified by the question he withdrew, that the state did something wrong in not producing these documents in response to the FOI request.
In acknowledgement of that objection, will withdraw the question. There isn't evidence of discovery. However, there's an expectation of disclosure. But you understand that the department, in dealing with a civil claim such as BGD's, has at their fingertips a whole range of documentation which goes to demonstrate a level of knowledge. You understand that?
As Dr Hodgkinson provided evidence yesterday, and as I did in response to a query from Councillor Sisting, there are some 80,000 kilometres of end-to-end documents. They go back decades, and it isn't the case that they were all filed correctly, administratively, in categories and by order, and that is most unfortunate. It was not a deliberate act, and the process of discovering these documents, there's no deliberate act that I'm aware of withholding documents. There is the practical reality of trying to locate documents, working in good faith to do so under FOI. As I also pointed out, we in fact discovered just recently a file we've been looking for since 1999 that sat inside of another file, completely unrelated to it, in a case that does not in any way relate to what that file was about. So that is just the reality of what we're trying to deal with, and we're working very hard to try and systematise it and work through it.
Do you accept that when BGD was considering the case against the department, the absence of these documents may well have formulated her view as to the prospect of the case, the prospects of success in the case?
I don't know what her view might have been. I just know that provision of all documents would be preferable to not. Yeah. And it is the case that there were documents that have been discovered and provided since, and that's all I know.
Had those documents been available to her, she is now of the view, I'd ask you to accept and understand, that she would have thought she had a much stronger case against the department than she thought she had back in 2011. Do you appreciate that?
If that's what you're relaying to me, I have not heard that.
That is her
then I
view
accept.
of things.
I accept that if that's her view.
And in that sense, she came to a settlement with the state, absent the full knowledge of her case against the state. You understand and appreciate that?
Your Honour, Mr O'Brien is giving evidence of what BGD thinks, and then asking
very well
the witness whether he accepts that's what she says she thinks. Your Honour,
the objection's been accepted, Mr Sherry.
Thank you, Your Honour.
In paragraph 136 of BGD's statement, so she says, I wanted an acknowledgement from the department that they'd done the wrong thing. I never received an apology or formal written acknowledgement from the department that they had screwed up. You have delivered an apology this afternoon to many, including BGD. And you accept, do you then, that in the words of BGD, the department did screw up in her case?
So I did offer an apology today, and I do offer a written apology as part of the new settlement process that's been in operation over a couple of years. It is the case that prior to the settlement process, that those who were involved in seeking compensation did not get anything written as an apology. If it is the case that BGD and others who previously had sought compensation but outside of the current settlement process would find it of some comfort to receive a letter, I'd be prepared to work with the Royal Commission staff in particular to ascertain that and provide an apology, as I do to people who go through the system now. And I say work through the Commission because I don't want in any way through some mass-produced system re-traumatise people by suddenly receiving a letter which they may not want. But it may be the case that those who have sought compensation prior to our settlement system now, if they would find it of comfort to receive an apology, I will do so.
Just going back to the latter part of that question then, she has said you screwed up. Do you accept that form of words that you screwed up in her case?
Look, anyone who has listened to the evidence and the witness accounts of this, they can't draw many other conclusions than that the system failed.
And then going back to your previous question, in terms of redress, are you offering survivors of abuse within these institutions further forms of redress, notwithstanding previous attempts at compensation and settlements?
Look, that issue is actually within the scope of the consultation document that's been released by the government, and it's a consultation document that I think closes in October, and I'm fairly certain that'll be an issue that this Commission itself will be looking at. What is the scope of the redress scheme? And so I will await the results of the consultation process and indeed look to the advice that governments around the country will get from the Commission on that.
Thanks. Nothing further.
Mr Gillespie-Jones.
Turana. My name's Gillespie-Jones and I appear on behalf of Joseph Marriage-Ancevic. He was awarded in 1961 and was a trainee at Turana in 1965-1966. And as such, I suppose he would fall into the same category as Mr Latham for that period of time. Likewise, similar to Mr Latham, does the department accept that the department failed to keep him safe?
Look, in my apology, I referred to all of that, and in response to, I think, counsel for Mr Latham Carl, I made very similar comments. And again, based on the witness statement, one cannot help but come to that conclusion.
Okay. And it represents both systems failure and policy failure that existed in the 1960s. Would that be fair?
Yes, I think you could draw that conclusion.
Now, with respect to the policies for Turana, going back to that period of time, you note, and I'll just read what you have in your statement. This is at paragraph 26 of the second statement. The Turana Objectives 1987 outline a requirement to implement a clear procedure for Turana in relation to allegations / complaints made by wards. You remember putting that in one of your statements?
Yes, I have that here.
Okay. Would it be fair to say that prior to 1987 that there were no clear procedures with respect to complaints? They were done on an ad hoc basis. Would that be fair?
Look, I think there were policies and procedures in place in terms of incidents that occurred within the institution, and my reading of them, they were primarily or overwhelmingly focused on child to child.
Yes. I suppose, all right.
Because there is evidence of incident hearings and things like that referred to in some of those earlier manuals.
Given what we've heard from Mr Cadd and people being kept in the same rooms, essentially, at that point in time, what could possibly go wrong? It would be disaster after disaster at those times, wouldn't there?
That's why we don't do that anymore.
Now, going to the department's policies with respect to incident reporting. And I'll just read you what you've got in the same statement at paragraph 56. Makes it easier for everyone here. An incident reporting system was developed in the early 1980s. Although there are a number of institutional specific policies, it does not appear from the records of the department that there was a comprehensive department-wide policy before then for reporting and responding to incidents. So is that the situation so far as your investigations have led you to believe?
Yes, at the time, yes, that's right.
And and I noticed that paragraph 57, you refer to a comprehensive manual known as Wardship Guidelines, detailed the case planning and policies with respect to wards of the state as at the 2nd of July 1981, including, amongst other things, a guideline in respect of absconding. Now, prior to 1981, were there any guidelines for wards from the department?
With respect to absconding?
With respect to anything?
I'm not certain of that.
So the answer is we don't know?
I'm not certain of that. There may well have been. I can clarify.
Okay. Now, in any event, going from either the departmental absconding policies and procedures to the Turana policy and procedures, what policy and procedures could you point with respect to absconding or complaints as at the 1960s?
I'm not able to say. I don't recall finding much material on that with respect to absconding.
Okay. And what about complaints against staff by trainees?
Certainly in the 70s, there is reference to, in some of the material, to particularly, as I mentioned, client child to child, and the requirement for hearings within an institution. I cannot recall for the 60s.
So, have you made any inquiries about the 60s?
I have been, but I'm not in a position to. I don't have a conclusive answer for you.
Yes, thank you.
Your Honour, just for the benefit of my learned friends, I note that those assisting the Royal Commission called for the department to produce these policies, and there are some policies that have been provided. Some are undated but appear likely to relate to the 1960s and likely to relate to Turana. So I direct my learned friends' attention to the Policies Tender Bundle Part A, Historical Institutional Policies Volume 2 of 2, just out of fairness to this witness, because the department has provided those policies previously.
Indebted to my friend.
Mr Sherry.
Thank you, Your Honour. Dr Phillip, you've said it on 3 or 4 occasions, maybe more, that you're happy to look into something and follow something up to provide further information.
Yes.
I take it you're more than happy to assist the Royal Commission in any way they wish.
Absolutely, yes.
And do you think, would that extend to allowing Commission staff to visit some of these centres if they wish?
Look, I think that if the commissioners or staff would like to, we can make available an opportunity to visit Parkville or Malmesbury to see for yourself what the current facilities are like.
You've also said, I think, that you, on several occasions, that you'll look into the particular circumstances of any particular case.
Yes.
And is your offer to provide assistance extend to former wards or former detainees?
Yes.
And they should contact your department?
Yes, and they can do that through a number of means. There are support services, there's Open Place, there's also the department more generally. Yes.
Thank you, sir. And you were discussing a few minutes ago, I think it was in relation to examination, the question of written apologies.
Yes.
And I think you said something about that you didn't think it would be a good idea to have a whole-scale mail-out because that might actually traumatise former wars.
Yes.
Could you explain what you meant by that?
Look, I don't know, but I could only assume that not everyone would be keen to get a letter from a department that was involved in the extraordinary trauma that a lot of them faced. I don't want to assume that people would love to get a letter from that department, so I just want to, out of concern for them, but by no means to restrict access to this. It's an offer to do this in a sensitive manner where it would be helpful rather than reignite some trauma.
Is it your experience that sometimes the families of former clients don't know about their mother or father's or grandfather's or grandmother's experience?
And we have heard that in witness statements already, yes.
And therefore, in particular, those people may not want to receive a letter disclosing.
Yes, correct.
Those events. You were asked some questions about the processes for staff reporting misconduct, in particular sexual assaults, by other staff upon clients. Do you recall that?
Yes.
Do you have any recent experience of that happening?
Look, we have one of the changes that is now in place is the encouragement of all staff to be vigilant to abuse, whether that be child to child or indeed staff to child. And we now have we do have staff who report on other staff now. And I think that is because we are trying to engender a value system in our staff to look after the interests of the children in particular, notwithstanding that this is within a corrections facility.
So you were asked by Dr. Dwyer about whether the health and sex education program includes the topic of speaking out about sexual abuse. Do you recall that?
Yes.
Could you have a look at your first statement and at paragraph 95? Look at the fifth last line, the sentence that starts, in accordance with these requirements.
Yes.
Is that what you had in mind?
Yes.
And there's a footnote there to a departmental document entitled "What I Need to Know: Rights and Rules in Youth Justice Custodial Precincts."
Correct.
Is that the way clients are informed about their rights?
Yes, amongst other things, including it's not just a one-off thing. So on arrival, they will be provided with an information pack like that, along with other information, and including as part of orientation, that is, where the unit is, meeting other staff, meeting other children.
And if you look at your third statement, sir, at paragraphs 185 to 186, that also talks about education about these issues, doesn't it?
Yes, so through the health service and through the education program that's delivered, this information is provided.
Can I ask you about the case management approach? As I understand it, for each child there is designed a case management plan as to how to support, help, handle that child. Is that correct?
Correct.
And if you go to your third statement at paragraph 107 to 115, you set out the detail of that.
Correct.
And it includes input from a variety of different agencies.
Yes.
Is that correct? If the child who is being cared for, the child in care, is himself or herself living with a former client as a parent or a grandparent even,
Yes.
does that take it into account in the case management of the particular child?
Yes, it is.
And why is it relevant?
So we may have, for instance, a child who has come through our child protection system. Child protection has a number of elements to it. One of them focused purely around the child, but there is a recognition that ideally for most children, the home is the most loving place for them and the best place for them. But it recognises that families at various times for different reasons may need support. And so we try and, in some instances, not put people through a statutory system. We try and wrap other services around them. And if they do come into our statutory system and come into juvenile justice system and then they're going out, well, we recognise that they're going to go back to a place that may need some support. And if we can do that, and if they can then live a better life, well, that's a good thing.
Is that a phenomenon that occurs, that children of subsequent, 2 or even 3 generations have come within the care of your department?
Yes. Yes.
I suppose that poses particular issues and difficulties.
It does, and and they're not easy. But in many ways, a lot of the families are open to the support that is provided, and they all have aspirations for their children and their grandchildren. Particularly, I've spoken to a few former wards of the state. Their aspirations for their grandchildren are enormous, and whatever can be done to realise that potential is, I think, the duty of a civil society.
And is that a particular area where a focus on prevention is highly desirable?
Yes, yes.
You said at one stage, I forget whose questions you were answering, but you said at one stage there were 80,000 kilometres of files. I think you meant 80,000 metres, didn't you? I think Dr Hodgkinson's evidence was it was 80 kilometres. Do you recall that?
Sorry, 80 kilometres. Yes, I apologise. Thank you for correcting me.
Surprised Dr Dwyer didn't correct you. And finally, sir, you're taken to some documents by Mr George, I think it was. You remember in relation to the procedures for reporting to police?
Yes.
Your Honour, could I ask for that document to be brought back onto the screen? It's DHS.300.030.0020.
Is that on your screen now, Dr. Phil?
Not quite, yeah. Oh, I see.
You can see that now.
Yes. Can you see that on your screen?
Yes, I can.
Dr Phillip?
I can.
And I think you were asked about, could we just scroll down a bit, please, to the bottom of the page? I think you were asked about those paragraphs at the foot of the page.
Correct.
And could we just scroll back up to the top? I don't think you were asked about this one, inexplicably.
Yes.
You see the heading, contacting the police?
Yes.
And in particular, do you see the second bullet point, sir?
Yes.
The Department of Human Services staff must report all allegations of incidents of a criminal nature, including assaults, to management and inform the police.
Correct.
See that?
Correct.
Could we go to the next page, please? Or page 3, all right? Page 3 of 7, and its DHS number is DHS dot... We've got it?
Yes.
And can we scroll down to the reporting heading? And you see in the third paragraph, Dr. Phillip, it says, for allegations of physical or sexual assault, refer to the policy, and then there's a bold title,
Yes.
reporting allegations of sexual assault to the police.
Correct.
Department of Human Services, 2005. I think you also weren't taken to that.
Yes.
Can I hand up a copy of that document? Your Honour, I should say that I'm informed that this document is not on Ringtail because it's a publicly available document, and apparently the protocol is produce documents that were not publicly available.
So just describe now, Mr. Sherry, what it is that's
Yes, Your Honour.
being
If
handed up, please.
Your Honour has Dr. Phillips, I think it's the first statement, isn't it? In the first statement, in paragraph, well, on page 34, in paragraph 103, there is a footnote, 33, and the footnote is this document. And there is a web, what do you call it, a hyperlink to the document. So the document I'm referring to is Human Services responding to allegations of physical or sexual assault. And then it says it's available at a particular site, a URL, I think they call it. So that's the document. Do you have that in front of you now, sir? Do you have the hard copy in front of you?
This document?
I
I'm sorry,
don't have that.
It'd be necessary for Dr. Phillip to have it, Your Honour. We only have
Only got one copy?
one copy. I'm
Or
afraid.
two, one you're holding on to?
Yes, sir. Look, yes, ma'am, I mean. Your Honour, Dr. Phillip, could you just turn to page 6, and then I'll hand up my copy to the Commission
Correct.
so that they can follow your evidence. Could you describe what page 6 says about reporting to police?
This is Title Section 3, Reporting the Allegation to Police. It provides guidance about when and how to report an allegation of assault to police and has a diagrammatical representation of it.
You mean a flow chart?
A flow chart. Immediate response to an allegation of assault. It starts with allegation of physical or sexual assault. The next arrow leads to ensure a safe environment for clients and staff. Next arrow leads to call for immediate medical assistance if needed. Listen carefully to and reassure the client. Preserve forensic evidence. And the next arrow leads to advise client that police will be called. And the next arrow leads to call police. If an immediate response is required, call 000.
Thank you, Dr. Phillip. We don't have any further questions, John. Oh, I should tender. Well, do I need to tender it? It is referenced in the statement, but I can tender it, or Dr. Dwyer perhaps might want to tender it. Yeah.
For the convenience of the Commission, I tender that document,
Yes,
Your Honour.
30.47.
And Your Honour, I had intended to earlier, and I'm not sure that I did, tender the Victorian Ombudsman report that I referred the witness to earlier. That's the Ombudsman Recommendations, third report on the implementation, February 2014.
30.48.
Your Honour, I'm sorry to interrupt Councillor Sisting, but I wonder if I might have a look at that document that's just been tendered, Your Honour. It was as a response to my examination of the witness, and I'm not sure if it's the same document that I have in front of me or a different document. Thank you, Your Honour.
Just briefly, sir, on the issue of negotiations over compensation or redress, you would accept that there is an obligation on the state to negotiate in good faith based on as complete an understanding as possible of the conditions of a former ward and the circumstances of their abuse. You would accept also, wouldn't you, that former wards are often vulnerable and that they will often find the process of discovering their files extremely difficult?
Yes.
And we've heard ample evidence in relation to the difficulty of obtaining complete records. In those circumstances, you would accept as a general proposition that the department would need to do everything possible in preparation for a civil claim to obtain all files.
Correct.
And it would be completely inadequate if as complete a search as possible was not done by the department to obtain all the files for a ward and to provide them.
To the best of our abilities, yes.
Yes. Sir, I'm not sure if you would have had an opportunity to see a supplementary statement that's come from Norman Latham, a survivor who gave evidence before these proceedings. But if I can read to you paragraph 7 of his supplementary statement. He talks about concerns and fears he has about what may be ahead if he has to go into aged care. He says the thought of having to go into a home sometimes triggers memories of abuse. I fear being vulnerable and helpless in such an environment. Those fears that have been expressed by Mr Latham are not uncommon. Many survivors have expressed to the Royal Commission that as a result of the abuse that they suffered, which has been far-reaching, and as a result of their issues in terms of lack of education and trauma, they have a fear of being institutionalised again in aged care facilities. What is the state doing to look after former wards as they age, given that there were so many failings in the care and protection of them when they were children?
So aged care is quite a different regime, but there are probably some issues that we ought to take from the experience that we've been party to during this Royal Commission to that. In terms of explicit policies around former wards of the state and aged care, I'm not aware of explicit steps that have been taken to ensure that any move into aged care is smooth and as less traumatic as it otherwise might be, and that care and attention is provided as is required in a dignified and respectful way. The regulations around aged care in our system lie with the Commonwealth Government, and it's something I can raise with my counterpart at the Commonwealth to see if there is anything that can be done in this area. That's not a hard thing to do, and so I'm prepared to do that.
And it's an issue that you, as the Secretary of the Department, would be prepared to hear more about from survivors as they express their concerns and fears around that.
And outside of this, I've already given a commitment to someone to meet with them and talk through some of these issues.
Thank you. Nothing further.
Thank you, Dr. Phillip. Just one final matter, and it touches upon the report of Commissioner Geary. So you gave evidence to us this morning that indeed you understood that Commissioner Geary was meeting with some of your senior staff to have a general discussion.
I asked him to do that, and I spoke to him last night.
Thank you. With respect to the report that's now been made public,
yes.
You obviously appreciate that it contains 9 specific recommendations.
Yes.
So my question to you is directly with respect to those recommendations, a number of which touch upon issues relevant to the Royal Commission.
Yes.
What can you tell us at this stage is the response of the department to those recommendations?
Commissioner, the government has responded publicly to Commissioner Geary's report. They've accepted all the recommendations in principle. Commissioner Geary asked me what that meant in principle, and I said there are some fine details. For instance, there was a recommendation about reducing the number of children in residential care. His figure's 500 down to 300, but we need to do work case by case on those in order to... you can't just do that straight away. There are a lot of safeguards that you need to put in place. So in principle, we agree with that. And one of the things I have spoken to him is how we might set up a process to actually look at these children case by case to determine the most appropriate setting for them and put in all the safeguards. Because for a lot of children in this space, we do find the failures of the system sometimes are on some of those really basic things. The care plan didn't make a lot of sense sometimes. There were gaps. People didn't follow up. So I think in order to implement his recommendations, there has to be a carefully thought out process, and I will work, in fact, with Commissioner Geary on a lot of those. And the government has also accepted these in principle and has already made a start on some of these.
So as I indicated to you, a number of those recommendations and indeed the contents of the report, a number of those areas are of specific relevance to the terms of reference of this Royal Commission. Yes. So it may well be that the Royal Commission recalls you at some later stage to have you explain exactly where the department is with respect to the responses to these recommendations.
Commissioner, we could, as we progress, provide updates to the Commission on how we're going.
Thank you.
Your Honour, thank you for that opportunity. I don't want to labour the point at all, but I thought it was good that I'd been unfair to this witness. And what I put to him before lunch didn't intend that. And I just draw the Commission's attention to 3.4 in that document that my friends referred to the diagram in. It's headed responsibility for reporting. Thank you.
Nothing further?
No, Your Honour. Thank you.
Thank you, Dr. Phillip. Thank you for your attendance at the Royal Commission. You're now excused.
There is a matter that arises before the next stage of proceedings. I make an application on instructions to vary slightly a pseudonym order in relation to my client.
Yes.
I've discussed this and the reason for it with counsel assisting and her instructors, and the documentation has been drafted. And I asked
Ed, has it?
It has, Your Honour. I hand up the proposed direction to you.
And you don't oppose that application?
I do
for
not, Your Honour.
variation?
I do not.
Thank you. So just to be clear, Mr O'Brien, this is seeking a variation to a direction that touches upon the way in which your client has been referred to during the proceedings.
Thank you.
Just so that it's not a mystery to anyone else at the bar table, it only touches upon your client.
It does.
I'll make that direction in the terms in which it's sought.
Thank you.
And Your Honour, might I also proposed directions in relation to what happens from here on.
Yes.
Might I propose directions that counsel assisting, that is myself and those who assist the Royal Commission, provide written submissions to the Royal Commission by the 2nd of October 2015, and that written submissions in reply be made to the Royal Commission within 5 weeks of the date that submissions of counsel assisting are served, and that any further written submissions in reply be provided to the Royal Commission within 2 weeks of the day that the submissions from other parties are served. The opportunity to make oral submissions to address written submissions will be provided if required. Submissions in that case would be heard in Sydney on a date to be advised. So might I hand up a written direction to that effect, Your Honour? There are multiple copies there which would be provided to other parties.
Thank you. Anyone want to say anything about those directions being sought in those terms? Yes, I will make those directions in the terms in which they're sought.
May it please the Commissioner. And that completes the proceedings for today, Your Honour.
Thank you. And so, as is understood, I think, by those who've previously followed these proceedings, that completes the evidence, and the next stage of the proceedings is that those written submissions will be prepared and exchanged between the parties, and once all of the written submissions are in, the usual course is that they will then be published, but up until that time are not published until the written submission process is completed.
Thank you, Your Honour.
Thank you.